Hello, everybody. Welcome to Joe the Lawyer. Today, I'm going to do an analysis of the first week of trial on the Kyle Rittenhouse case. This analysis is coming from a professional trial attorney. In fact, the reason I didn't make videos all week is because I was doing a jury trial. The jury in the trial I did was on a DUI, and the case ended up deadlocked, hung jury. So we may have to go and have the trial again. We will see what happens. Anyway, thank you everybody for tuning in. I'm Joe Pometto, Joe the Lawyer. If you like my content, please like, subscribe, comment, and share. Free way to support the show. I do legal analysis, legal news, and give legal information here on this show from a practicing criminal defense, family law, injury attorney in Pittsburgh, PA. Okay, let's dig into the content here. 4 takeaways from the first week of the Kyle Rittenhouse trial. Now, let me tell you, I have not been personally watching this, okay? I haven't been watching this personally. But there's a lot of information to be gleaned, and I have been watching the case from the very beginning. All right, let's do a quick same time sip before we dig in. Cheers to everybody. I got some black, delicious coffee, Lavazza, an Italian coffee brand, which I actually drank a couple of times when I was in Italy. Anyway, everybody, cheers. Delicious. The first week of testimony has come to a close in the trial of Kyle Rittenhouse, the 18-year-old charged with homicide after he shot and killed 2 protesters/rioters/looters at a demonstration in Kenosha, Wisconsin in August 2020. The protest began after police shot Jacob Blake, a 29-year-old black man, on August 23rd, leaving him paralyzed from the waist down. Multiple nights of unrest followed, with rioters destroying police cars and burning and damaging businesses. In a series of confrontations with rioters, Rittenhouse shot and killed 2 protesters, Joseph Rosenbaum and Anthony Huber, and wounded a third, Gage Grosskreutz. Rittenhouse faces 7 total charges, 2 counts of homicide, 1 reckless, 1 intentional, and 2 counts of recklessly endangering safety. He has pled not guilty to all charges. If he pled guilty, we wouldn't be having a trial. The prosecution still has yet to wrap up their case. Among the remaining witnesses is Grosskreutz, who is expected to testify Monday. Let me tell you, he is going to be a very key witness. For obvious reasons, right? He was shot. He was there during one of the shooting transactions. So the jury is going to really want to hear what he has to say. The defense will take over later next week. Whether Rittenhouse himself will testify, normally common in self-defense cases, is still an open question, in part because there has been so much video evidence of the events. Closing arguments are expected by the end of the week or sometime in the week of November 15th. So here's what I'm going to say about Rittenhouse himself testifying. I believe that it is, I think, and I have not seen all the video. And as you're going to see here, some new video of the incident was shown to the jury that regular consumers of news haven't seen. I think that Rittenhouse is going to need to testify, or that it would boost his case if he did. I'm saying that without seeing the video. But here's the thing with self-defense. A jury is going to want to hear what the experience of the shooter was. In order to truly communicate that, I believe that the person claiming self-defense has to sit there and tell the jury why he did what he did and what his moment-to-moment experience was in those moments. That's extremely powerful. The defense attorney is going to have to ask those jurors to step into his shoes, step into the shoes of the person that's claiming self-defense and ask themselves, would they do the same thing? And if Kyle Rittenhouse gets on the stand and says he feared for his life during these transactions, and if the evidence supports that, at least to some degree, that could be the type of evidence that could get him past the finish line. In self-defense is technically an affirmative defense. And so the way that it works is normally in criminal trials, only the prosecution has a burden to prove, right? They have to prove beyond a reasonable doubt the person is guilty of the charge as it stands. But if you claim self-defense, that is something that you must prove affirmatively as a defendant. That's why it's called an affirmative defense. So there has to be some level of evidence that has to be established in order for the self-defense to, let's say, annihilate the other charges. Because when you claim self-defense, you're not saying, oh, I didn't do it, which is the defense in most criminal cases. You're not saying it wasn't me, it was somebody else. You're not saying you don't have the evidence to show that I was the shooter. It's not what you're saying. You're saying as the defense, you do have the evidence to show that I was a shooter. It is true that I shot this person. It is true that I shot this person and they died. But I was justified in doing it. And in order to truly communicate that message, I believe, and you'll hear in the rest of this article, that Rittenhouse should testify. I think it increases his chances of winning. Pivotal testimony about the first shooting came from a video producer at a right-wing news site. Nearly 3 hours of testimony Thursday came from Richard McGinnis, a video producer with the news site The Daily Caller. I'm sorry, I'm not going to put... I just can't. I can't handle, whether you're labeling a news station liberal or right. I'm not going to do it. So I'm just going to take that out. I believe that colors the opinion of individuals reading this article. It's a bit disingenuous, but overall, this is a good article. Besides that. McGinnis was in Kenosha that night covering the protests as a journalist. Rittenhouse's encounter with Rosenbaum, the first person he shot, is critical to the prosecution's efforts to characterize Rittenhouse as an initial aggressor whose reckless actions led directly to the violent confrontations that followed. And that right there gives you another clue. You can see even how this journalist is characterizing it. The prosecution is going to have a really hard time, I think, showing murder one or like some intentional homicide here. It could happen, but I think they're going to have a harder time. Something along the lines of reckless or negligent homicide, I think, is more likely. Rittenhouse's encounter with Rosenbaum, the first person he shot, is critical. But video evidence of that encounter with Rosenbaum is sparse, meaning the testimony of McGinnis as the person who was closest to the shooter is crucial to both sides. On the stand Thursday, McGinnis described the atmosphere that night as dangerous and menacing, in large part due to the presence of so many armed men. McGinnis conducted an interview with Rittenhouse about 15 minutes before the first shooting, in which Rittenhouse described himself as an adult, an EMT, and a medic. A little strange. Our job is to protect this business, and part of my job is to also help people. If there's somebody hurt, I'm running into harm's way. That's why I have my rifle, because I can protect myself, obviously, Rittenhouse said in the video. Well, that's a little bit of testimony from Rittenhouse right there. Later, McGinnis testified he saw Rittenhouse running toward a used car lot, holding both the rifle and a fire extinguisher. McGinnis decided to follow him, reaching for his phone to record. In the lot, Rittenhouse stopped and turned around. Rosenbaum was not armed, McGinnis said, but he continued to run toward Rittenhouse. That's Mr. McGinnis right there. It was clear to me it was a situation where it was likely something dangerous was going to happen, be it Mr. Rosenbaum grabbing it or Rittenhouse shooting it. Rosenbaum lunged for the rifle, McGinnis said, and Rittenhouse dodged. As Rosenbaum's momentum was carrying him past Rittenhouse, Rittenhouse fired 4 times. Afterward, Rittenhouse ran away, leaving Rosenbaum lying face down on the ground. You can sort of see that in the grainy video that came out. It was released to the public. When prosecutor Thomas Binger suggested it was impossible for McGinnis to know what Rosenbaum was trying to do as he lunged, McGinnis replied, well, he said, F you, and reached for the weapon. Prosecutors showed cell phone videos of McGinnis trying to help Rosenbaum after the shooting. Cheers. In the videos, McGinnis can be seen turning Rosenbaum's body over and McGinnis taking off his own shirt to try to stem the bleeding. In testimony, he described that he felt in danger and afraid as he did so. I'm sure. And good on Mr. McGinnis for taking some action here. Watching the videos as he sat on the witness stand, McGinnis appeared to grow emotional. Because McGinnis was close to the line of fire, Rittenhouse has been charged with recklessly endangering his safety with a dangerous weapon, a felony. That's really going to depend on how close he actually was. But that might be something. Well, again, if Rittenhouse was justified in shooting this individual, even though there was another individual close by, what the defense would do is they're going to shift that responsibility onto the aggressor, the person, this Rosenbaum. They're going to shift the responsibility onto him and say that Rittenhouse would have never shot close to McGinnis if Rosenbaum wasn't being so aggressive. A good attorney will do that. Two other armed men who came to Kenosha that night were also key witnesses. Prosecutors have worked to characterize Rittenhouse as a reckless aggressor whose unreasonable initial actions, namely shooting Rosenbaum, led directly to the confrontations that followed. On Thursday and Friday, they called two witnesses who were among the self-styled militiamen in Kenosha that night with the intention of protecting local businesses. That included Ryan Bouch, who described Rittenhouse as a little under-equipped and a little under-experienced, and a former Marine rifleman named Jason Likowski, who was standing with Rittenhouse in the moments leading up to the shootings armed with an AR-15. In his testimony, Likowski described using a shout, shove, show, shoot philosophy. First, he would try shouting. If that didn't work, he would shove, then show the weapon, then shoot. Likowski testified he never felt the need to progress past shout that night, including during his encounter with Rosenbaum shortly before Rittenhouse shot him. Rosenbaum was acting very belligerently, Likowski said, yelling for Likowski to shoot him and making sudden stops toward him, trying to provoke a reaction. Rather than shoot, Likowski said he chose to turn away. After he'd done that a few times, I turned my back to him and ignored him, he said, describing Rosenbaum as a babbling idiot and repeatedly testifying that he believed Rosenbaum did not pose a danger to himself or anybody else. I really didn't see him as a threat at all, to be honest with you. Defense lawyer Corey Chirafisi countered by pointing out differences between the two accounters and questioning Likowski's memory. There's a little bit of good stuff for both sides in that individual's testimony. Because he says that Rosenbaum was belligerent, acting a little crazy, coming towards him. But, this guy had the maturity, the knowledge, the experience to understand that that Rosenbaum wasn't actually a threat. But that does not mean that Rosenbaum wasn't acting more threatening towards somebody else, especially somebody young like Rittenhouse, who's just not going to have the experience, knowledge, life knowledge to understand, that maybe this individual is just a goof. And look, even if you have that experience and knowledge, you just never know with people. So really, I think that testimony may actually help the defense more so than the prosecution. Videos have played a prominent role, including never-before-seen FBI infrared footage. The events of August 25th, 2020 were thoroughly documented by live streamers, reporters, and photographs, a unique benefit for the jury, the judge said Friday. And both the prosecution and defense have turned repeatedly to photos and videos. Defense lawyers showed a series of photos they said revealed the people Rittenhouse encountered were armed, be it with guns or other objects. Prosecutors have showed many videos, several of them graphic, including the video recorded by McGinnis as he attempted to treat Rosenbaum's wound. That's going to be a powerful image. In addition to the widely shared photos and videos, the jury also saw something new. Infrared footage of Rittenhouse's encounter with Rosenbaum recorded from an overhead by an FBI airplane. That blows me away. Is the FBI recording everything all the time? It's wild that they caught that. Or maybe they're just recording that entire area of Kenosha where the action was. Wild. Surveillance these days. Woo! The video appears to show that, at first, Rittenhouse was pursuing Rosenbaum into the used car lot. Rosenbaum appears to pause between two cars as Rittenhouse runs around them. Then, Rosenbaum appears to chase Rittenhouse before Rittenhouse stops and shoots him. The defense is also expected to rely on video evidence, so much so they may not call Rittenhouse to the stand, which would be relatively unusual for a self-defense case. Jessa Getz, a Wisconsin criminal defense attorney, said, "It's usually the testimony that establishes self-defense is an issue. Normally, there isn't all this video footage. Regardless, I again, my opinion is, and maybe the defense can win this case without Rittenhouse's testimony. He is a young kid, but I think their case would be better with his testimony. I'm going to predict that he does testify. The judge is not taking risks with the jury in public confidence. On Thursday, Judge Bruce Schroeder dismissed one of the 20 jurors for making a joke about Jacob Blake, whose shooting by police triggered the protest. The public needs to be confident this is a fair trial. The juror, an older white man, was being escorted to his car on Wednesday evening by a court police officer when he told the joke. The officer then reported the joke to the court. It was my understanding it was something along the lines of, why did the Kenosha police shoot Jacob Blake 7 times, said prosecutor Thomas Binger. It's my understanding that the rest of the joke is because they ran out of bullets. Let me just say this, that joke is repugnant, disgusting, and that juror has no place at all sitting on a jury probably ever again. It's clear that the appearance of bias is present and it would seriously undermine the outcome of the case, Schroeder said as he dismissed the juror. Good on Judge Schroeder. Schroeder, who's currently the longest serving judge in Wisconsin, which I did not know, has drawn public attention already during the case, in part due to his pretrial decision that prosecutors could not refer to those killed by Rittenhouse as victims, while the defense lawyers may call them rioters or looters. Here's the thing about that opinion. I believe he said that they can only label them rioters and looters if the facts show that they were rioting or looting. The facts may not, in fact, show this. If there's nothing to show that these individuals who were shot were actually rioting and looting, then I don't believe the judge is going to allow the defense to label them as that. And from what I've seen so far, that evidence has not been submitted. So I said in my earlier episode, I thought the judge should let them be called victims and then also let them be called rioters or looters, and just let the chips fall where they may. But maybe he's keeping both out, and I think that also may be a fair result. He's got strong opinions on how he conducts his courtroom. Sometimes differently than other people do. But he's knowledgeable, has a lot of experience, and you don't mess around in his courtroom. Good for him. I really love and respect judges like that. So that's the first week of trial. I did predict the trial would take a couple of weeks. I thought jury selection would take longer than it did. It went by a bit quicker than I thought. We're probably looking at one more week of trial, perhaps by the end of next week, the closing arguments, or perhaps early in the week after, we'll see closing arguments. I think so far the evidence favors the Rittenhouse defense. I also believe that they're going to have a hard time getting intentional homicide here. If the Commonwealth gets anything, it's going to be, the Commonwealth, state of Wisconsin. It's going to be involuntary or reckless homicide, or voluntary recklessly endangering another person, something along those lines. I think that they have a higher chance of getting that. And I also think that it would be a good idea for Rittenhouse to testify in his own defense. All right, everybody, thank you for tuning in to Joe the Lawyer, Joe Pometto. I'm a family criminal defense and injury attorney in Pittsburgh, PA. If you like my content, please like, subscribe, comment, and share. I really need that free support to grow the channel. All right, thank you very much.